Get started. We're Donna. We're getting started. Yeah.
Sorry, there's no upstairs.
Hi everybody, my name's Aida Aslanian and I'm an appellate attorney, and I will try today to connect with you guys on some of the issues of visitation, especially in reference to what we're starting to see or we would like to see in the record, so that we are best able to protect our mutual clients in the various scenarios that are developing. And I'm going to be skipping around a little bit, but I want you to understand that I'm looking at things primarily from my point of view, and what I'm attempting to impart to you is the things that I and other appellate attorneys would like to see in the record, sometimes are hoping to see in the record, and it's not always developed. Because you have to bear in mind, as appellate attorneys, we cannot introduce new factual matters. The courts will not allow it. We cannot present arguments that were not at least presented in the trial court, even if they were ultimately denied. If there has bin no mention of something in the trial court, the courts of appeal take a very bad view of us raising it for the first time on appeal. And I know I've also held the line when the department tries to do as much, and have argued the same, that appellate courts are not courts of trial, they're courts of review. And with that in mind, I'd like to approach some of the issues that I would like to speak about today. And one of them being that, and this is just not my input, it's a lot of us appellate attorneys. When we have a termination of FR, and for whatever reason, the parent has been unable to reunify with the child, perhaps they've fallen off the wagon one last time, whatever. But up until that period of time, we've had good visitation, and it's reported as good. Parents coming in with toys and food and spending hours of time visiting 2 to 3 hours a week with the child. A child is responsive, runs up to the parent, yes mommy, yes daddy, whatever. So we have the court say, okay, you're out of time, we are terminating reunification services. And then in some courts and in some jurisdictions, more than others, the next thing that follows is, and now mom or dad who's been visiting 4 times a week, you only get one visit for 1 hour once a month. There is no showing of detriment. There is no argument that the child would benefit from this extreme reduction in visitation time. And yet, no one seems to argue against it. Parents' attorneys, minors' attorneys say nothing when the reduction goes in. And the 2-6 is set, and 120 days, and we're going to proceed to adoption. Nothing is being said. Now, on appeal, I'm stuck with that nothing. And the problem here is that some departments have even come in and said, hey, this is our policy. We have a local policy. When we terminate FR, or when the court terminates FR, our policy is to only allow 1 visit a month. And my response to that is, So local policy is abrogating statutory law. Is that what we're saying? We're allowing local policy to take away from statutory law that says visitation should be as frequent as possible, which is in the best interest of the child. And those who have deemed to even respond to it have said, in responding briefing, have said, well, yes, we don't think it's in the best interest of the child, because the child is slated to go for adoption, and we don't want to confuse the child, because in 3 months adoption may be ordered. And my response to that, again, is any confusion from an adoption, if an adoption is in fact ordered by the court, can be addressed subsequent to the adoption with therapy once the child is in the adoptive home. Why penalize the child and the parent from the relationship when there has been no showing of detriment and no showing of any reason to attenuate the relationship between child and parent? The second issue I have with that is that, in fact, this policy, point blank, foreseeably, is taking away from the parent's ability to argue the C1B1 exception when the adoption proceeding does take place, because the frequent contact has been attenuated. It is much more as it is, and as we all know. The C1B1 exception is one of the most argued and the least successful throughout the state, recognized by all the courts of appeal. In fact, it's become almost an illusory kind of an argument. I don't know why we have the statute if nobody's going to enforce it. That being said, it's even worse to have the department intentionally attenuate that relationship and foreseeably affect the parent's ability to bring forth that argument at the adoption hearing. And I think that is an improper use of any local policy, any courtroom, and I don't think it serves anybody. I don't think it serves the child, I don't think it serves the parent, and I don't think it serves the system. Unfortunately, whenever I have argued that in appeal, the answer has been, the issue's forfeited. It was never challenged in the trial court. So please, folks, if nothing else, do a cursory challenge if you are confronted with this kind of a situation, so that on appeal, those of us who have to carry the ball have something to raise and say, look, the court abused its discretion because this was argued and it denied without any evidence that it was detrimental to the child. It's worth a shot, and at least it's something that we can protect easily at the trial court level. Then one thing I've seen, and I'm not sure I've got the answer, but I certainly have the questions, is when we have a special needs child, and I've noticed that, at least in the appeals I have been doing, there seems to be a great reluctance to liberalize the parents' visits with a special needs child, even when the parent is addressing whatever the parent needs to address, be it drugs, be it alcohol, and be it mental health. Now, mental health is tricky in and of itself for the parent, but let's say whatever it is, we have glowing reports about this parent coming on board and doing everything that we have promised them that if they do, reunification should be accomplished. And then we have the department who starts finding reasons why the special needs child should not be, the visit should not be more liberalized. Well, mom may not know the actual medical condition. Well, there may be a therapy that mom is unfamiliar with, that the child is undergoing for developmental problems. And I think that then it comes down to trial court level for the attorneys, for the parents to ask from the get-go a more specifically designed case plan that allows the parent to become part of that process, that allows the parent to be able to, those that are able to, go to medical appointments along with the foster parents to get information, perhaps from the doctors that are treating the child, to attend therapy sessions for the child. And what I have seen in some cases is when in fact the parent is coming aboard and is able to actually perform at a level where they can participate in these special classes, all of a sudden the arena for providing the services is changed to the foster home, which, because it is confidential, the parent cannot access and is unable to participate. And then we come back to the 12 or month hearing or whatever, and it is, the argument is made, well, the parent knows nothing about Junior's problem, so we can't possibly liberalize. We have to go ahead and terminate reunification services. And I suggest we start thinking, if that's the case, we start thinking in terms of, well, have reasonable services been provided here? We knew from get-go the limitations of the child. We knew from get-go the limitations of the parents. And these generalistic, parenting classes for age-appropriate children may well be, but did we design something in there that says, hey, think about the special needs of the kid, and think about providing the parent with these specialized services, or maybe hands-on experiences. This is something that has to be addressed from the very beginning, because we're going to bump into it at the end of the line, and on appeal, we may or may not be able to raise a reasonable services argument, but again, that depends whether it was even approached in the trial court. Because if not, my friend, the forfeiture is going to hit me right in the face. And there is a lot that can be done. I think that, granted, not all parents are going to be able to step up to the plate. But for those who are, and for the children that they have in the system, we deserve to give them a sporting chance. And if you have had any kind of experiences in this regard that you want to share or you think we can use on appeal, by all means, please do not be reticent. I know that I personally like to keep a very close ongoing dialogue with trial counsel, and those who will allow me, we will talk ad infinitum. And have.
Yes.
But I can only learn from the experiences of trial counsel because you guys are in the trenches. I see it after the fact from a cuckoo's point of view, but I need the people who have everyday experiences to bring us nuances so that we can start adopting our arguments on appeal. And I also need you people to make the arguments during the trial court that I can extrapolate and then raise on appeal. Because we're a team. I can't work without you guys, and I can't raise things that aren't there, as much as I have attempted to in the past. And then we have almost the counterpart of that, but it's the flip side from the parent's point of view. And I'm seeing cases where mom, it's usually mom, but not always, or dad, has a mental health issue. And it's increasingly becoming a problem, at least in the appeals that I'm seeing. Okay, if reunification is our goal, then what are we doing to prepare this parent, provided one is willing and able to follow the regimen and takes the meds and does everything proper, and we have reports from therapists that are saying, this mom is now turning around, has stabilized, this whatever. So what then can we do to start positioning these parents to start having some unmonitored visitation, to have a little longer visits? It's a dicey situation. I can see an avoidance of risk. I can see a liability issue, but by the same token, if we're never going to allow these people to reunify with their children, then we should tell them up front, you're done when the case comes in, and not torture everybody with review hearings. But that's not what the law provides, and until it changes, we all have an obligation to work within the system to try and bring about some kind of reunification. And I understand it's not easy. I don't know how I would react if that responsibility were placed on my shoulders in the trial court or as the judicial officer. But we need to go beyond the preconceived ideology of mental health being a definitive something that's going to prevent parenting. And I don't think we've arrived at that situation yet. I think we all read or see mental health and flags go up of all kinds. We read and see labels such as schizophrenia, bipolar, manic depressive, and all sorts of learned responses come into place that I think we need to re-educate ourselves, the bench, and everybody else, because things are changing. If nothing else, look at the commercials on TV. You can't get away from it. The little blue pill that will fix everything, and you will be, super mom and super dad within whatever. But there is certainly a movement out there that this is a disease like any other. We wouldn't think of discriminating against the parent because they got diabetes. We wouldn't think of discriminating against the parent if they have cancer. Why is it that when they have an illness that's mental illness, we nevertheless allow the prejudices to come in? I'm not sure I got the answers, but at least if you guys, in the proper cases, feel you can make the arguments in good conscience, since we're all officers of the court, then I think that on appeal, in the proper cases, we can pick that up and move it forward. And I think that the courts of appeal are starting to be a little more amenable. They're saying, just from the fact of mental illness, you cannot assume this parent is an endangerment to the child. We're starting to see a little bit of change in that direction. I think we need to push it a little forward. And I was talking to some people before the lecture started in an area which I won't cover because I think it's developing and I don't know what the answers, not even what the questions are. But now that we have a legitimization of marijuana, how is that going to play out in the dependency court? How is that going to play out in the pleadings, in the visitation we allow, in continued visitation, liberalization, and even in return? Are we going to, in fact, hold to the old standards and say as long as there's drug use, a child may not come home? Will that still hold if they have a legitimate marijuana card and a medical marijuana card? It's a question that is yet to be answered, but I think the groundwork is going to have to depend on stuff that takes place in the trial court. Because I can tell you for a fact, the courts of appeal will not entertain it for the first time on appeal. The first time I raised it, that it was an infringement of the Compassionate Act, I believe I got creamed. It was, and I forget the case name, which is cited often, but maybe that's why I blocked it. But interestingly enough, in 2 years afterwards, in the case of Drake M., the same judicial officer, the same court, did a total about-face and came up with the decision saying, hey, just because dad is using doesn't mean he's endangering the kid. So there's room for progress. And it's going to be a challenge because I don't know how the parameters of this are going to play both in the trial court and certainly not on appeal. Now, another thing that I've seen that has affected in some cases, and in one particular case I'm thinking about, Visitation, was where, and the facts, I'm going to give general since I can't confuse the cases. I may be confusing the cases anyway, but it's a situation where you have parents who are otherwise good parents, appear to be taking good care of the children, but dad is running a drug selling business off the premises, or has, he's an entrepreneur. He's a working man. So the wife may or may not know, but certainly it is not affecting the quality of the care that the children are getting. Children are impervious to any of this, and they have great relationship with the parents. The department comes in, it's a sting operation, they take dad, they may even take mom, and they're relatives in the neighborhood. I'm going to neighborhood meaning within a 15-mile, 20-mile radius. But the department doesn't place with any of the relatives, even though some seem to be legitimate, that would pass clearances, and places the children 80 miles away. And their justification for this is that, well, given dad's activity, there may be retaliation against family, and we don't want the children to be hurt in the process. Okay, that seems to be a consideration, although I didn't see anything in the record where they had investigated other alternatives, where they had investigated whether the relatives would be able to safeguard. Perhaps there may have even been somebody in law enforcement amongst those relatives. I don't know, because it was not ever looked into. And instead, we had the children placed far away. And in so doing, there was no assistance provided for the parents to visit. And they would travel at their own cost, long distances, to be able to visit perhaps for an hour or two. And what I labeled, and of course there was a criminal case pending, and what I think the intent in that case was really that they were trying, not so much that they were concerned as much about the safety of the children, as safeguarding the integrity of any testimonies those kids would perform or give in the upcoming criminal trial. So they were acting in lieu of a witness protection program. And my first argument was, dependency is not intended to be a witness protection program. We are here to reunify parents with children. And if you put all the impediments in the world in that process for reasons unrelated to dependency, and there was no showing really that mom, let's say, was anything other than unable to protect, then the justification for putting a child that far away was unwarranted. Into the equation then comes, if you splinter the children in 4 different foster homes, whose best interest are you protecting? Now the parents have even a more splintered approach to visitation, perhaps in different geographical locations. The children have been split apart in a way they don't understand why, and what part of that is in the best interest of the children, not to mention where does this in any way move towards fostering reunification. These are, and I think in those situations, it is appropriate to come back and ask the courts to make orders for the department to account what closer homes it has investigated, when, whether it could accommodate all the placement of the children, and what is the proximity of those homes to the parents' environment, so that they can keep up constant and more and visit more often. Because even when the courts make an order saying, department, tell me what other foster homes you've looked into, all I usually get, and what you usually get in the record, is something that says, and we investigated other homes and they were improper, so we're leaving the kids 80 miles away. Well, as far as I'm concerned, that's not good enough. I want to know, who did you talk to, what homes did you look, what vicinity, what radius did you look, what dates did you look, and why was it, and were you looking for placement of 3 of the children or just 1 at a time? And I think that information is pertinent to the court, that information is pertinent for us, and it's important for the parents. We need to know what efforts have been put in. And if the order is not complied with, I think you may think about perhaps suggesting that it should be brought within 10 days, a supplemental report, may want to come in, and if not, ask the court for an OSC re-sanctions. We cannot artificially separate parents from their children and impair their ability to visit on issues that really have nothing to do with the dependency process. And unless the parents are shown to be detrimental to the children, unless there's a concrete showing of some kind of endangerment, speculative endangerment, I think, is insufficient to curtail visitation or liberalization of visitation. And I think once, you know, and the other problem becomes, it becomes a fait accompli. You set the kids 80 miles away, and now let's say the criminal case is resolved, whatever, but the kids are still 80 miles away. What efforts are being made to bring them back in now? Now that there's no more a big question of endangerment, because the testimonies and everything are over and done with. I see subsequently that nothing is being done. And that leaves the parents in a very precarious position. It puts upon them the burden to visit, to try and liberalize the visits. If so, where are the visits going to be liberalized? Where are the visits going to take place? There are a lot of things that need to be worked out, and the place to work them out is in the trial court. The details have to be worked out in the trial court. In that particular case, I think, if I recall correctly, there was a happy ending in the sense that the parents relocated, moved closer to the children, and were able to visit, and I think in time they were able to get the kids back. But I can't suggest that as an alternative for us having provided reunification services. And, okay. Now, something that's probably not as exciting, but is just as important, is that, well, I guess I should start from the beginning. I'm seeing, and I'm very encouraged in seeing in the records, that trial counsel for parents are coming in at get-go and asking for a written visitation schedule which can be implemented at detention or shortly thereafter. And the court says, yes, I order a written visitation schedule. And one thing that is not always put in the order, and I think it should, is that the parents be consulted in the social worker devising this visitation schedule. Because sometimes the only people that are consulted is the foster parents. Well, the foster parents' availability and the parents' ability to visit should not, the foster parents' availability should not impede the parents' ability to visit as often as possible, which is the precursor of having to then liberalize the visits. So we should have times and places which are amenable, and perhaps a meeting of the minds and a meeting between the two, is if the children are placed far away, that the parents can participate in visits that happen more often and are more productive, so that we can move then to liberalization. But what I see in the orders is this plain order, DCFS, write the visitation order. Next thing I see is DCFS has written one, but it doesn't fit the parent, and the parent is complaining, hey, you said it during my working hours, you said it during the time I'm doing parenting, I can't comply with this, and yet that there's no meshing. Once the department takes a position, hey, we gave you the visitation order, then it's up to the parent to comply with it, and that puts them at a disadvantage if they have other things going in being able to reunify. I think there should, and sometimes the court makes the order and there's no follow-up. We come back the next, in a month, specifically for that reason, and I see the department making one excuse after another as to why they have not implemented this plan. Again, I suggest that as parents' attorneys, we think about suggesting an OSC re-sanctions, because I think if the department starts understanding that we are very serious about enforcing the court's orders, and that we want them to perform as ordered by the court without excuses, that they're going to start honoring these orders of the court in a proper time frame to allow the parent to be able to reunify, to allow the parent to be able to visit more often, and not to be able to fault the parent for the inadequate visitation schedule that has been established. So, again, I guess there's some work to be done. And unfortunately, it starts with trial counsel, but believe me, we at the appellate level will be more than happy to carry the ball once you set it in motion, because we're seeing a lot of this. And I'm seeing even as late as the 12-month review, where we're still dinkering with the place of visitation and the foster parent doesn't think she can make it here, and we're not liberalizing because there haven't been enough visits, and we don't know the quality of the visits, and we don't know how the parent is going to react. Well, everything is contingent on everything else. And if we don't set the ball in motion from arraignment detention, and even as late as disposition, with each passing phase of the proceeding, the court becomes less interested, and the final analysis may be that we're unable to liberalize visits enough for a reunification. And of course, it's a two-way process. I know, as many of you, that sometimes our clients wait till the next 6-month review hearing to let us know that they haven't been getting their visitation. We come into the 6-month review and it's the first time we find out, gee, I haven't had one visit because I call the social worker all the time, she doesn't respond to my calls. I try and set it on such and such a date, the social worker changes the time period on me. And what I used to suggest to my clients when I was in that position, which I was for 5 years, I used to practice out of 412 in Genzer's Court. During the years 1995 to 2000. I would suggest to my clients, start keeping a diary. Get a cheap calendar from the dollar store and start marking down. I called social worker today at 3:30, couldn't get a hold. I called social worker at 4:30 and no answer, or she told me to wait till the next hearing to bring it to the court's attention. And I would tell my clients, don't wait for the 6 months. Call me back within a month. If you're not getting your visits, call me back. I'll have a recourse. I can do a walk-in. I can walk-on. I can do a 388. I can do anything to try and safeguard your rights, but I must know about it ahead of time. I must know about it in order to amass the documentation in case I have to file a 388. If I'm presented with it for the first time at the 6-month review, there's not much I can do other than pure argument, and sometimes it doesn't fly. So this is something that has to be set up between you and your client early on. There is another problematic area with visitation, and that unfortunately is mostly having to do with dads. Dads, a mom independency from get-go is recognized as a mom, and she has rights, and she has enforceable rights, and things flow from it. A dad comes in, and he has to prove that he is either at the least biological, and the best is that he is presumed dead. Now this process can take some time. And let's say that for whatever reason, we have a KLCS kind of a situation. Father's prevented from coming to court in the earlier stages of the proceedings due to fraud of mom, whatever, not being notified, etc. He comes in, he asks for a DNA test, especially if he's been told by mom or other parents, other people in the family, you may not be the dad. And that process takes another couple of months. Now, some courts are doing two things. Some courts are saying, okay, Dad, we're going to start visits for you pending the DNA testing, and then we will re-examine it again at that stage and see where we go from there. Other courts are saying, we're going to hold off any contact until we find out if you're even bio-dad. And I would suggest that you have a very serious discussion with your client when he first comes in and you're appointed for that man. Is he truly going to want to be a dad to this child? Does he want to parent, whether he is bio-dad or not? If he says yes, then let's pursue reunification from get-go. Because case law says he doesn't have to be bio-dad to be able to become presumed or even quasi-presumed. And we have cases that have extended the quasi-presumed of KLCS to non-biological dads. In fact, our own department, Division 7 has done that in Jerry P. So if in fact the man is serious about wanting to be a dad to this kid, give him the tools or ask for them. If it doesn't happen, you may consider about appealing it. That may take some time, however, so you may consider going to your friendly writ attorney and discussing the issue with them. They may be able to take fast court action where we cannot. And the reason I'm saying this is because lately there seems to be a backlog, and I'm getting appeals 8 months after they were filed or more. And then that's in cases where we have the entire record, which may not always be there, which we need to then ask for, which takes another couple of months to complete. So all that time, if you're relying on an appeal, it's not doing that man any service. And then if we come back, okay, so that's get-go. If the guy wants to really be a dad, fine. If he says no, I'll wait and see if this child is mine before I make a commitment to the child, then he needs to be explained that, you know what, in 2-3 months, the court may not extend to you any visitation or any kind of services, because the case progresses and some judicial officers are taking the position that, hey, kid's been in foster care, adoptive parents all this time, I'm not going to disturb him. You came too late into the case. You didn't visit until you were determined to be a father, and therefore, I'm not going to give you any visitation and the story for that man. This is a risk the parent has to be advised of and take. He needs to know. So, the courts on appeal have been dicey on this issue. Some have said yes, there's been a due process violation, especially in cases where the father was artificially prevented from coming, meaning mom tells him, you're not dead, you're not dead, you're not dead. Meaning social services doesn't bother looking for him even when they have an inkling that he may be a father, because they have another man that has shown up. And the courts have said, some courts say, yeah, let's give him a sporting chance. Let's give him 6 months of visit or whatever. Other courts have said, tough luck, you came too late. Kid's about to be adopted. I'm not going to disturb his psyche by allowing you to enter his life. I have argued on the side of allowing the parent a sporting chance. I think the parent deserves a due process chance to parent his own kid, especially in cases where he's non-offending, when there is nothing wrong with the man, other than he came on the scene a little too late because of circumstances beyond his control. I've had mixed results. But I think that we need to pursue that, because also remember, now California recognizes more than 2 parents for a child. And it's not good enough for someone in the trial court to say, well, you know, we already have a presumed father, we got the mom, what more do we need to crowd the kid's life with any additional men? But that isn't the law. The law has recognized that in appropriate cases and where it is in the best interest of the child, that we look at the 3rd parent, and then if we have to decide which of the competing fathers, if there are competing fathers, which best serves, which under the weightier policy considerations is going to provide, we're going to safeguard and we're going to recognize as the father of the child. This area is becoming extremely complex. It is not my intent today to go into it, but every case that comes out seems to tweak it one way or another. I don't think we have any definitive answers, but at least if you raise the issues, then on appeal, we have the luxury you don't have in the trial courts. We have the 2,000 pages of transcript to sit and read and distill, sometimes over and over, until we come up with an analysis of the situation. You may have the report on that morning. Moreover, you may not be the initial attorney, and this is what I'm also seeing. There's been a lot of turnover, and not every attorney who comes into the case is aware of everything that's gone on before. There is a change of counsel. Sometimes there's a change of judicial officers, minors counsel, and there are hearings that I see where literally nobody really seems to know what was on calendar, what the issues were, what the prior orders were, so they can extrapolate and go forward. And I think it's not beyond our powers to say that if in fact we are the new attorney on the case and I'm hit with a 60-page report, then Your Honor, I would like an extension of time so that I can distill this report. I was not trial counsel at the last hearing. I think that most courts would willingly grant us a little time to familiarize ourselves with what went on so that we can make the proper decisions when we come back. But again, I recognize very well your caseloads, and I recognize that sometimes you don't have that discretion, but in proper circumstances you may consider it. And, okay. Now, there's one area that's developing that, frankly, I definitely do not know the answers. And that's the area of the incorrigible teenager cases that we're starting to see. Thanks to the Supreme Court, who has determined in their wisdom that irregardless of how good of a parent they may have, that child belongs in dependency, and that child is subject to our reunification efforts. We now have a parent whom we want to reunify and who may want to reunify with the child, but what are the tools for this parent? What kind of visitation do we grant this parent with the runaway child that half the time can't be even kept in the foster homes? It's a challenge. What kind of, and one of the things that plays into it is visits under a therapeutic setting. Gee, that's wonderful. To be decided by minors counsel, by minors therapist when she's ready. Well, I've seen cases where minors therapist comes in and testifies, it's not my call to make that conjoint determination. My focus is my client who has other issues. I do not want to be put in a position to make that recommendation nor to conduct those conjoint sessions. Parent counsel, parent therapist may be saying by the same token, hey, mom is ready, willing, and able. Let's get going. Where are those conjoint counselings? And nothing is happening in the trial court. Over and over and over. This is another one of those situations that seems to get away. And I think perhaps a suggestion from the beginning, we should ask that an independent therapist be assigned for the conjoint. Then mom can take care of her business with her therapist without a commingling of therapy. Child can take care of her issues, and their mutual issues they can take care of together in conjoint counseling. I don't see why that has to wait till they resolve whatever issues they have with the rest of the world or themselves. That's a very narrow area. It's interpersonal relationship between mom and the child, which obviously hasn't worked for the 16 years or 17 years that it's been going on. So I think we already know, we're very focused on the issue of that conjoint counseling. We should be instituting it from the beginning to at least provide both sides a place to talk. Because otherwise, I don't think those parents are getting visits. It's your call, it's your discretion, I'm just throwing it out as a possible alternative. Okay, I think I'm pretty much mostly done with the stuff I wanted to cover. You guys have any questions that are non-specific to any case, and the reason I say that is because we have multiple legal firms here, and because in years past I was part of the litigation when CLC commingled the ethical laws that we ended up having to bring litigation to ensure that they were properly maintained. So I don't think I want to answer any specific, but if you have nicely couched hypotheticals, if I can give it a shot, I will, and if I don't know the answer, you'll hear it too. Anyone have any questions of any kind? Yes?
Can you talk a little bit about when you have kids that are refusing to visit or declining to visit? This comes up all the time. It's particularly problematic with the older kids because you can't just pick them up and put them in the car, but it's bleeding into even younger and younger children. So can you talk about the record that you'd like to see on those cases?
I agree, and I have a big problem with that as well because...
Can you repeat the question, please?
Yes. The question was, how do we address the issue increasingly coming into the courts where the children are refusing to visit the parents? And this is becoming not just a problem with the older children, but it's now permeating down to the younger children. And unfortunately, my first answer to that will be that I don't have an answer, because I don't know. On the one hand, as one judicial officer recently said, they are